Hello, good afternoon and good morning, everyone, depending on where you are dialing in from. Welcome to this afternoon's session where we're going to be discussing some Nigerian competition law. My name is Michael-James Currie. I am a Pan-African competition lawyer and a director of Primerio based in Johannesburg. And I'm very pleased that I am joined by representatives of the Nigerian Competition Commission, Ms. Eme, who is the Chief Legal Officer, as well as Yemisi, who is from the mergers, an analyst in the mergers division. Thank you very much to you both for availing yourselves to chat to me today.
Thank you, Mike. Good afternoon, everyone.
Thank you very much.
I think today's session is particularly timely for two reasons. One is Nigeria as the largest economy on the African continent, certainly by GDP, I think requires a competition law regime. I think it's of significant interest not only to your local market, but to significant players across the continent and indeed the world. And secondly, and perhaps more importantly, albeit a more medium to long-term view, as the African Continental Free Trade Agreement is being negotiated and competition policy in particular is being negotiated, I think it's going to be critical that there is a strong voice from a variety of national territories and national agencies, particularly from the more developed economies, to ensure that there is a balanced policy and balanced view, and that there is an effective competition enforcement with the view of having a sort of Africa-wide competition regime, much like we see in Europe. And I think it's therefore, we know South Africa has for many years been considered the lodestar of competition agencies on the continent, but we have seen the rapid rise of national agencies across the region, particularly in the southern and eastern side, but of course, the likes of Egypt and several other agencies are increasingly active. And I think the Western African region, both with Nigeria as well as Cameroon and CMAC as a regional body coming on stream, is particularly good and only bodes well for competition policy across the continent. For the benefit of the audience, I think what I want to discuss with our two representatives today can broadly be fitted into three themes. One, to get some insight from the Commission as to sort of the state of play in relation to restrictive practices and enforcement trends outside of merger control. I then want to unpack the leniency regime in Nigeria, coupled with penalty guidelines, as well as the approach that the Commission takes to criminal prosecution, criminal offences. I think that is of particular interest for anyone who has an interest in the Nigerian economy and is active there. And then, of course, we will discuss merger control, which I think for most of our audience members is a key interest, and one which I have no doubt Yemisi will provide much insight into later on in this discussion. Eme, let me turn to you first. We know the Commission has only very recently been established. We think, certainly I think, there have been tremendous strides made in the past 12 to 18 months, not only in the establishment of the Commission and resourcing the Commission, the agency itself, but also the attempts made at publishing several regulations and guidelines, many of which are still in draft form and open for public comment and not yet finalized. But I think it does give practitioners and firms some good insight into how the Commission is thinking about certain things, the direction the Commission is going, or I wouldn't say going, but the issues which the Commission has taken cognizance of. And I think at the outset, in many ways, the Commission is in a fortunate position, and it seems that you have somewhat of a blank slate in the sense of being able to draw from the experiences of jurisdictions all over the world and have the benefit of taking precedent from Europe, US, South Africa, and other jurisdictions, and really fashioning your legislative framework to take cognizance of many of those issues. Now, I don't think we'll be able to get into the nitty-gritty of all of them, but perhaps, Eme, give us some insight into currently what is the Commission busy with? What are some of the enforcement trends you've seen, or policy, well, I wouldn't say policy objectives, but perhaps priority sectors that have been identified? And perhaps you can give the audience some preliminary insights into what the Commission has been up to sort of outside of the merger control front.
Thank you very much, Mike. Hello, everyone. So basically, like you already said, the Commission has actually been quite busy, and it's fortunate that we have this broad sheet of experience all across the world to glean from, because it's really like served as a guide to us. So far, when we initially started, the Commission was basically focused on merger control, because we understood that at that point, undertakings were already engaged in acquisitions and leases and purchases and all of that. So when we first came in, it was important that we do not destabilize the market. And with the passage of the FCCPA, we could see the Investments and Securities Act, certain sections of it being repealed, and those sections were already being implemented. Merger control was then housed with the Securities and Exchange Commission. So when we came on board, we realized that we didn't have the much needed capacity and tools. So it would have been foolhardy to just barge into the market and try to just upturn things and all of that. So the Commission basically, first of all, which was all out there in the market, we went into an MOU with the SEC for joint review of mergers. And basically what was happening was that merger notifications were being reviewed by both agencies. So we had the FCCPC team who was working with the SEC team to basically really get a hand of how things are being done. And at the expiration of that understanding, the FCCPC commenced operations fully on its own. You would even see sometime a few months ago, we had to come up with certain amendments to our regulations for thresholds having to do with equity trust funds and all of that, because the Commission is very interested in ensuring that the market is stabilized. So we do not just want to be seen as just working, but you have already said we maintain an open door policy. And in the meantime, at the moment, we are working on finalizing our abuse of dominance regulations, restrictive agreements, and trade practices regulations, notice on market definitions. We are also putting out advisories out there to undertakings on certain behaviors. In terms of enforcement, we recently, we were in the news, we had intel, we obtained and executed a judicial search warrant for 5 shipping and freight forwarding companies. Basically, intel gathered showed that they had been coordinating and carrying out anti-competitive practices both within Nigeria and outside Nigeria. And so we were able to get that search warrant. We executed it. And at the moment, discoveries are ongoing. Also, the Commission is looking at the conduct of the personnel of the undertakings, because the law requires that they provide assistance and reasonable facilities to its officers while they're executing any warrant of whatever sort it is. So the Commission is acting on certain things that may have occurred in the course of execution of the search warrant. we've also issued out some publications, some advisory on soft loans. We've seen this trend where consumers or people who are not involved in particular transactions have been sent SMS telling them how someone they know borrowed money and didn't pay and all of that, and just generally slandering people's character. So we are looking to see the terms of operations. We're looking to see licensing. We're looking to see how it works with financial institutions, and just basically clean up the market space and ensure that, yes, if you are engaging in credit, in giving out credit facilities, you should also be subject to certain laws and all of that. Then in the area of consumer protection, we are also basically always, we came from consumer protection. So it took us a while to get used to the fact that when you are analyzing cases and all of that, it's not just about consumer protection. You also have to protect the market as well. So we're working on balancing to ensure that consumers are protected, consumers have fair choice, consumers, that the market is innovative and everything just works on smoothly. So we also keep an open door policy. On the draft regulations that were published and sent out into the public, we've had stakeholders who have reverted back to the commission on their submissions, what they think, how this would work better and all of that. And so we're just willing to listen to the concerns and input of industry stakeholders, and also learning from our international, our big brothers and sisters like South African Commission. We also have other international organizations and other competition agencies that are working with us and telling us, okay, we have consultants with the World Bank who have had to help us consult with us in drafting our regulations and all of that. So we're not just working on our own. We are pulling in our resources from everywhere to make sure that the Nigerian market, which is very unique and very wide and very essential in ensuring that the African continent, the economic welfare of citizens, of consumers and all of that just works well. So yeah, the commission is really, really busy. We've been so busy, and we hope to do some more.
Thanks, Emma. I mean, that's a great introduction and great overview. I think it's absolutely sensible that you didn't want to sort of take a bull in the China shop approach once you were given your powers. But it seems quite clear that notwithstanding the various draft regulations, that hasn't precluded the Commission from taking proactive steps in investigating not only consumer protection issues, which you're well familiar with, but of course, consumer competition issues. And perhaps that leads me to the next question, which is, one of the first and most pressing issues I think most firms would ask when subject to an investigation is what are the sort of due process and procedural fairness standards that apply. Perhaps you could, very briefly talk us through an investigation and a case, and put firms perhaps at ease at the level of due process protocol that the Commission does follow.
Okay, so basically, the Commission can instigate investigations on its own suo motu, or it can receive intel. We've had occasions where people have written in and basically said this undertaking is engaging in this and all of that. We would ask for, if we would on our own carry out some surveillance if it's something that's, for example, this enforcement that we just recently carried out. What the Commission did was that after it had received its intel, it went on surveillance to just basically browse through the area and see if there was any credibility to the intel it had received, and also for security reasons. So we needed to understand, we needed to know, we sat down basically and drew out a plan to understand, okay, this is our intel, this is what we've gotten on anti-competitive behavior. How do we proceed? Are we going to execute a search warrant, or would it be easier to just request for information or documents? But we realize that certain industries, certain undertakings will not be willing to just let go of relevant materials that will be necessary to assist the commission in its investigation. Usually that we find that happening more where there are allegations of consumer rights abuse. You would see the other party willing to say, oh, look at my books, this is what I did, this is how I went about it. You see them willing to provide intel and provide more details as to what happened. But when you come to competition, you see that it's beyond one consumer. These are people that most likely are just in one market and they're controlling. There's a cartel there. They would not want, it's inevitable that they wouldn't want to easily let go of relevant information. So we would carry out surveillance to verify the credibility of the information we've received and also to secure the area. And while that is ongoing, we would go to court because our law, yes, the FCCPA allows us to carry out search warrants on premises, but it needs to be authorized by a judge of the Federal High Court. So we need to go to court and apply for a search warrant that will be executed, and there's a time frame for execution and all of that. Once that is done, we would find staff of the commission executing the warrant, and basically the warrant allows us seize documents, seize files, extract information. So we would go through the entire office, and when we get in there, we do not just act like we are just, like you said, a bull in a Chinese cup, just go on and butt our heads with these people. We read the warrants, we let them know their rights. They have the rights for legal representation so that they understand what is going. They also need to understand that it is important to cooperate with the commission in executing its search warrant and providing all reasonable facility to properly execute that warrant. So once these documents are pulled up and all of that, we have seizure bags that are well tagged. Everything is tagged. It's not just walking into an office and just bundling things up. We tag them, we enter them, we log them, and we have people who also, representatives of these undertakings, that shadow our staff while we are in the premises, just to ensure that everything is done in an orderly manner. When we retrieve these documents, then we go through our discoveries. We try and put together a story, get our facts together. And this is by going through emails, going through documents, going through phone records and all of that, and basically build our case. If we've also had instances of obstruction, persons who have obstructed our investigation while we're on the premises, the law criminalizes that particular action. We may choose to prosecute or not. So while this is ongoing, we're still going through our documents. And if in a situation where, well, we've not yet, because like you said, we are still teaching, so we've not yet gotten to the point where a particular investigation has shown that those undertakings are not guilty per se. So I wouldn't really be able to speak to what would happen if this occurs. But if we find out that you have been contravening certain provisions of the law, parties may willingly choose to come under cooperation and assistance of the commission and just say, okay, you know what? Yeah, we did this, we did all of this. We would like to cooperate with you and see how we could mitigate our fines or penalty for our conduct and all of that. So if this is done, then we sit together with their lawyers, and definitely, I must add that entering into cooperation and assistance with the commission does not necessarily mean that you would not be prosecuted. The commission still has that discretion whether it would prosecute or not. But coming under our cooperation and assistance rules definitely would add to would definitely be some mitigating factor in your favor or in the undertaking's favor. So this is how our investigations run through, and then we prosecute if need be. But if it comes to consumer protection, infringement of consumer rights, when we receive these complaints, we send letters to the undertaking or persons involved. This is what has been alleged about you. We would like you to speak to it. We would like you to respond. We would like you to look into it and get back to us within a certain number of days. If they get back to us and there seems to be some contradiction in the stories, we might invite both parties for a mediation hearing just to hear both parties out and let them speak to themselves and try and reach an agreement. Sometimes we also could reach consent orders where the commission, the respondent says, okay, I did this, I'm willing to refund, I'm willing to repair, I'm willing to do that, and you find the consumer accepting. So we just, we basically have consumer rights infringements. Those are more, they're easier to deal with, and they do not last over an extended period of time, unlike anti-competitive investigations where you have to make sure your evidence is strong, you have sufficient evidence to actually put the undertakings involved to the book. So basically that's just how we run our investigations.
Okay, I mean, I want to come back to the leniency and cooperation in a moment, because I think that's a critical point. But before turning to the next question I wanted to ask, I should have mentioned that if anyone in the audience has questions, please feel free to raise them. We've made some provision for some questions to be asked and answered towards the end of the session, but if you feel you want to ask it now, and hopefully our panelists can address it during the course of their discussions, then please feel free to do so. Eme, so I think you've very helpfully set out the sort of commencement of these investigations, and certainly very sophisticated investigative tools and approaches that the Commission has used to date in terms of preserving evidence or treating evidence in the procedurally correct way. Turning to the actual substantive tests used, the regulations, albeit in draft form, are quite meticulous and very detailed in their drafting. And what's quite apparent is that the Commission has adopted both in this now specifically to sort of what's known as a hardcore cartel conduct, your collusion cases, and has both your by purpose and effects-based tests. What extent is there for parties who are subject to a maybe beyond an investigation, an actual complaint referral or a hearing, to lead pro-competitive evidence or evidence in order to justify their conduct or to demonstrate that the conduct did not in fact have any anti-competitive effects when dealing in hardcore horizontal conduct? Does the Commission adopt a very strict sort of per se prohibition, as is the case in South Africa, where there is no room essentially to raise pro-competitive evidence, or is the door ajar to do so?
So the status of purpose-based restriction agreements are illegal, and they are unlikely to be justified on efficiency grounds under Section 60 of the FCCPA. Basically, a justification for having a category of object infringements is referred to as the concept of risk offenses in general law. Example, driving under the influence of alcohol. Punishment is warranted wholly irrespective of whether certain danger or accident is endured. So restriction by object, it does more than creating a presumption of unlawfulness, but relates to actions that are by their very nature harmful to normal competition. They just reduce the need for further analysis. Restrictions identified as hardcore under the Act are unlikely to be considered indispensable there's really no argument to say that there's some efficiency to be achieved by carrying out this particular act. So I think the door is completely shut. I could be wrong, but based on the draft that has gone out, I would want to say that on that basis, that door is, for hardcore restrictions, is just, it's straightforward.
Okay. It's well, your view is that it's per se prohibited and completely blocked, except when there's potentially an exemption that applies.
Exactly. Yeah, definitely. So where?
Could you
go ahead? I'm listening.
I think you're going to address it now anyway. So go ahead. Yeah. I was going to say.
You're talking about block exemptions, yes. So when an
correct.
agreement is covered by a block exemption, parties generally are relieved of their burden of showing that their individual agreements satisfies the conditions laid out in the Act. They only just need to prove that those restrictive agreements benefit from a block exemption. So agreements warranting block exemption must contribute to improving production or distribution of products or services and contribute to promoting technical or economic progress. Definitely, consumers must receive a fair share of the resulting benefits. If there's going to be an increase in price, then there should be an increase in terms of quality and innovation. Consumers should say, okay, yes, there was this price increase, but this is the benefit that was derived from it. And those restrictions must be, they must be indispensable to the attainment of the objectives. It is not sufficient to say, oh, yes, we could have gotten it this way, but we chose to go about it this way, which is anti-competitive. It must be that it's indispensable to achieving the purpose of that agreement. And so then it would be accepted by the Commission. So, and we need to understand that the Commission will withdraw the benefit of a block exemption when it finds that in a particular case, an agreement covered by block exemptions, it has certain effects that are incompatible with the economic efficiency, fair share to consumers, indispensability of that restriction. So yes, those efficiencies, those particular conditions need to be met to enjoy the benefit of a block exemption and authorization from the Commission.
Okay. Maybe I'll move on, just looking at the time, maybe let's move on to just very briefly on abuse of dominance issues. Just the state of play. There's a couple of interesting aspects of the regulations, particularly the use of, or the notion of collective dominance. It's something which is in South Africa's legislation. It's been promulgated, but it hasn't yet been brought into effect for I suppose a number of reasons, and I see that is part of your legislation. I don't want you necessarily to address me on collective dominance or provide your inputs there, but the thresholds for dominance in Nigeria is currently based on market power, which is of course a very sensible test. Although we understand that there are going to be market share thresholds published in due course. Now, my question was whether you envisage those market share thresholds to be in the form of guidelines to enable parties to self-assess their potential dominance in the market, or whether those are going to be rigid thresholds like South Africa, where if you are, for example, have a market share of more than 45%, you are irrebuttably presumed to be dominant. Is it going to be as rigid as that, or is it just going to be, are you going to retain inherent discretion or inherent test of market power?
Oh, okay. So, Mike, I can't basically give a position because the Commission has not yet made its decision on how it intends to proceed in terms of market thresholds for dominance. But even if it's in form of a regulation, I would suppose that we would have some guidelines that would come with it just to provide clarity to the market, like we did in the merger review regulation, so that parties could easily assess themselves and just know whether they meet the threshold or whether they do not. So in as much as that is still in the pipelines, I would not want to take a position that would be contradictory to what the commission may eventually decide to go with. But I would like to assure the market that whatever decision we make, we would ensure that every interest is taken into consideration and that we provide proper clarity to the market so that parties are not confused as to whether they meet the threshold for dominance or they do not. And if it has to do with corporate dominance, I'm very sure that that will also be spelled out in the regulation and guidelines if it turns out that way.
Fair enough. Fair enough. Then let's turn to the earlier point you mentioned about leniency, and I think it might address one of the two questions that we've already been that we've seen come through. So we know that the Commission intends publishing leniency rules. It hasn't yet been published. We understand that parties can, however, and you intimated as much earlier, can, however, currently approach the Commission for leniency. Can you give us some insight into, is there any formal mechanism for it? Is it an informal mechanism? And perhaps more importantly, you made the remark that a party might approach the Commission, but has no guarantee that the Commission might not prosecute in due course. At what point in this process does a party then have certainty that once they've concluded either a consent order or an immunity leniency agreement, that they have some safety? And I think the question was quite pointed to: is an admission of guilt an absolute prerequisite for a party either settling with the Commission early on, or, well, I presume for obtaining immunity, it would have to be an admission of guilt, but perhaps for settling a matter with the Commission? Does it, I don't know if this is something the Commission has dealt with yet, but does the Commission, for example, in cases elect to waive a requirement of an admission of guilt for purposes of an expeditious and speedy resolution? Or is it a very principled approach from the Commission saying, well, if you want to settle the case with us, you must admit your liability and expose yourself to potential prosecution?
So where immunity would be granted where the participant is the first to submit information and evidence, which in the Commission's view will enable it carry out its investigations. So if you come in, basically you can come in formally. It has to be formal. You have to write to the Commission. There's no informal conversation about it. It has to be in black and white, because what's the assurance or the guarantee that after you've told me orally that you are willing to cooperate and assist, you don't just renege on your commitments to assisting the Commission? So we would definitely want to have that on paper. We would grant immunity where the disclosing party is the first to submit information and evidence that would really go far in helping the Commission in its investigation or carrying out targeted inspection, in, for example, where a cartel is involved and where the Commission did not have enough evidence before you approached it to carry out that investigation, or it's yet to even carry out that. But like I said, the Commission retains that inherent power to decide if a case warrants the grant of immunity from fines. But parties would need to understand that, yes, if you're coming under our cooperation and assistance rule, it has to be, you have to let it all out. You can't be willing to cooperate with us and you're still holding back on intel that would just make the journey, make the process shorter. It doesn't, I don't think it would even be, even when you're dealing with plea bargaining in the courts of law, you would see the accused coming out, okay, admitting to his crime, and then we can go into negotiating, sentencing, and conviction. So I think that also holds sway for the Commission. Yeah, yes, we would want that parties that are cooperating would cooperate and assist in full, and not just necessarily just giving us, feeding us with bits and pieces of information and then leaving us to go and figure it all out on our own. You would have to disclose all relevant information pertaining to the subject of the investigation, and may even be willing to go further in disclosing other infringements of the FCCP. And conduct in the course of investigation also plays a lot, has a lot of influence on the commission's decisions. If a party has, all through the investigation, you've obstructed the commission at every point in time, you've butted heads with the commission, you've done all of that, naturally, that's aggravated. And if you look at the administrative penalties regulations, you would see that, and when it comes to calculating fines and penalties, there's room for aggravating factors and room for mitigating factors. So your conduct in the course of the investigation has a lot to do with what the commission decides in your case. So the commission, yes, parties would benefit from reduced penalties, and if corporate penalty is guaranteed, directors may be protected from disqualification proceedings, where we see that they've been really cooperative with the investigation. So yeah, that's what it is.
No, I think that's very helpful. I mean, I do want to get into the penalty guidelines, and Yemisi, I might bring you in momentarily, but perhaps before we do that, another question was asked about the extent of the Commission's powers when conducting, for instance, search and seizure operations, and whether that is confined to only commercial premises, business premises, and or whether that can extend to their residential premises and or things like personal cell phones and mobiles. Now, it's obviously an important consideration for a variety of reasons, but I want you to consider this or address this also in the context of the fact that all prohibitions of the Act, all anti-competitive prohibitions in the Act, automatically attract a criminal sanction. It's a criminal offense. It's not just only hardcore cartel conduct. And so the first is, one can well imagine why there is some sensitivity if individuals know they could be personally liable. So perhaps you could address just the scope of the Commission's powers in that regard, A. But then B, well, let me ask you that to address that first, and then I'll ask my follow-up question.
Okay, so in terms of the scope of powers in executing our search warrant, you would have the warrant spelling it out exactly in clear terms. Seize documents, laptops, phones. And what happens is that if I use my phone for personal work, for official work, then my phone is a tool in my place of work. I would have official mails in my phone. I would have, for example, on my phone on the go, I have my office mail there. So I have mails dropping in. So yes, if you have used your personal belongings to carry out official assignments, the Commission is going to want to look at it. But we are going to definitely protect your privacy. We wouldn't go into invading your personal documents or your personal messages and mails and all of that. We try to ensure that we do not go beyond the scope of our powers, because that would be an abuse of powers. But if the scope of the warrant, for example, let me use the enforcement exercise, the enforcement that we just carried out. It was within the premises. It was in the official premises, but we had to collect personal phones, particularly phones of persons of interest, and mirror them and then sift through the information we've received. So we've gotten everything. We get intel from your phones, but we don't necessarily use it if it's not relevant to our investigation. That would amount to an abuse of powers. But so the scope is pretty wide, as long as that thing is being used for official communication or your official work. as it relates to, then yes, the commission is definitely going to take it.
Did you in this case use or make use of a third-party service provider who, for instance, who cloned the devices? And then if there's a dispute as to whether or not information is confidential or not, or legally privileged or not, or personal or not.
So we have our IT personnel who have been trained in going. So if we outsource cloning these devices, they just help us in retrieving. They do not have access to it. The only people that have access to it are personnel, staff of the commission. It's never outsiders. So no, and then, like I said, when we are carrying out or executing these search warrants, we have staff of the undertaking, different staff shadowing our agents, our officials at a point of search and execution. So that's just basically to say, okay, this is, yes, I was here, I saw this was taken, I attest to, and we even have them sign and attest to what we've picked up. So no, we might need to outsource getting, but you need to understand that our law allows us to authorize anyone to assist in its investigation. So once that person is an authorized officer, he is allowed to do that, but there's also a scope on what he is allowed to do and not do. But if it has to do with going through the information, no, we do not outsource that. We do that. We've had situations where we've been here till midnight, just going through documents, going through files and mails and all of that. We handle that on our own. We do not outsource that. That would just be.
I might come back to this because I think it's going to be an important point to discuss, and I think some of our audience members are particularly interested in this. But given the limited time we have, Yemisi, apologies for not bringing you in earlier, but perhaps you can give us some insight into, before we turn to some of the merger control issues, give us some insight into the penalty guidelines. And it's quite a complicated formula that the Commission seems to have published about how to go about calculating it. Without going into sort of granular details, give us a little bit of insight into how this applies, perhaps with reference to an example of maybe a cartel case versus a failure to notify case. And just talk the audience through about how that's applied in practice.
Okay, thank you very much, Mike. So the formula, like you said, it's a bit complicated, but the Commission is the only one. The Commission can only determine the final penalty for any violation because it's based on the Commission's discretion, where it allocates the percentage for the mitigating and the percentage for the aggravating factor. So at the end of the day, what stakeholders can calculate is just the base sum. So for example, you have a case of gun jumping. It says 2% of the annual turnover of the combined parties. In this case, you can only calculate the third party can only calculate the base sum, but cannot calculate further to the final penalty because the Commission has to determine what is the mitigating percentage and what is the aggravating percentage. So at the end of the day, the base sum is then multiplied by the duration of months in which this violation has taken place. So the regulation also points out points and how do I put it? The mitigating factors, example of mitigating factors and the examples of aggravating factors. So with these factors, the Commission will come to a determination of what the mitigating percentage is and what the aggravating percentage is. And when this is done, the whole formula kicks in. So that's why at the end of the day, the party involved cannot be the one to calculate the final sum.
And the turnover in this case, is that local turnover or global turnover for parties?
So it depends. there are cases where, for example, there's a case in the EU we've seen where we can actually penalize the global company if we see that all decisions made by the local company, no decision can be made by the local company except instructed by the foreign company, that's the parent company. So we can pierce the veil to see who is controlling this local company. So that's the case for, let's say, other competition issues that are not related to major gun jumping. So any other competition issue, the commission can pierce the veil to see who is controlling, and then the parent company can be dragged into the fine, penalty, and the investigation.
Okay, sorry, Yemisi. Mike, can I just add to what Yemisi said?
Yeah, absolutely.
So pursuant to Section 2 of the Act, the Commission's jurisdiction covers undertakings whose commercial activities occur within or have effects within Nigeria. So where a foreign entity is found to be in default as regards any anti-competitive practice, the Commission would apply the worldwide turnover of the entity. You know, she talked about control and all of that, but the Commission will take into consideration the facts of each case in deciding. But parties need to understand that the Commission's powers, in as much as is a foreign entity, as long as your activities have effect in Nigeria, then it's most likely that it would be worldwide. It would be the worldwide turnover that would apply. Particularly, we all know the principal and agent rule. The agent actually just acts in the stead of his principal. So if that is found to be the case, then yes, we would apply the worldwide turnover. So I just wanted to.
So if
powers allow us to do that.
Yeah, I think it's an important clarification or addition. So if, for example, a company, a parent company or at a parent level colluded in the United States, for example, and that company has a subsidiary in Nigeria who may or may not have known about it, let's assume didn't know about any of the collusion, but because that company, the parent company has a presence in Nigeria, and let's assume that the products subject to collusion were sold in Nigeria. What I understand you're saying is that there would be no preclusion when on the commission when fining that parent company on looking at their global turnover. It's not limited just their turnover in or from Nigeria. Yeah,
particularly where that collusion had an impact on the Nigerian market. If it was just in the US and the subsidiary is just here and there's really no effect, I don't think that it would even be an investigation here in Nigeria because there's no anti-competitive effect. But if we are able to trace it and we see that string of attachment running all through down into the Nigerian market, yes, definitely, we're going to look into it. But then, like I said, we always exercise the discretion in doing that. Yeah. So parties can make.
So once you get over the jurisdictional threshold issue, so there must be collusion, there must be an effect in Nigeria. But once that threshold, you can retain the discretion to consider whatever turnover you need to arrive.
Sorry, I didn't get that. Sorry, can you repeat that question?
So I said, once you get over the jurisdictional threshold, and you then essentially have the discretion to utilize global turnover in order to determine an appropriate penalty, and you'll do that on a case-by-case basis.
Yeah.
Okay. No, I was just summarizing
how I understand. Yeah, definitely.
Yeah. Okay. All right, then very briefly, because I'm cutting our merger control time quite short. Very briefly, Eme, can you give us the regulations, again, draft regulations, confirm that all prohibitions of anti-competitive conduct or violations of anti-competitive conduct attracts a criminal sanction. It mentions that the commission has a discretion to determine whether or not a criminal sanction should apply. Could you talk us through how you envisage that, or how the commission envisages that operating in practice? Does the commission, does it have the authority and the jurisdiction to issue criminal sanctions, or is that the responsibility of another agency? And you know, for some background, South Africa introduced criminal sanctions in our legislation back in 2016, and it's never been utilized. And I think for two key reasons. One is it's a national prosecuting authority who has to prosecute criminal conduct, and two, it may have a significant deterrent effect on people coming forward and admitting to contraventions if they might be, or if the commission can't guarantee them some form of safeguard from criminal sanctions. I just want to get is that something that's been considered? Is that something you've grappled with as a commission, or?
So, like we all know, I think basically it's really the courts that can convict for a crime, but generally prosecution of criminal matters in Nigeria lies within the state, and they exercise that power through the Ministry of Justice. Yes, the commission has and can exercise its discretion with respect to prosecution of criminal offenses under the FCCPC. Specifically, I must add that Section 113 says that the commission may prosecute or refer violations of criminal offenses to the Attorney General. But where the commission chooses to prosecute, definitely the standard of proof is going to be beyond reasonable doubt. That's the general standard of proof for criminal offenses as provided in the Evidence Act. But if it has to do with, ultimately the decision would lie with the court if the commission is prosecuting. But if we've had people who have come under our leniency, or undertakings who have come under our leniency or cooperation and assistance, it could be one of the benefits of coming under that look, the commission is not going to criminally prosecute you, will rather just issue a fine to you for your conduct. So yeah, the discretion lies within the commission, but in the event that we get to the courts, it is the courts that will determine the actual penalty for that criminal.
Understood. So I think in summary, not too dissimilar to the position in South Africa either.
Yeah.
Yemisi, getting you back involved on the merger front. We have witnessed over the last 18 months and a number of changes, both legislative changes as well as administrative / logistic changes, if you like. One of the key observations, certainly based on the clients we represent and you know the engagements we've had with the FCC over the last 12 months has been very much focused on foreign mergers, foreign parties to mergers. There have been a couple of developments in that regard, from having an expedited foreign to foreign merger regime to a position now where there are sort of three different stages, three different options or routes merging parties might want to consider. There have also been changes to the notification thresholds, the filing fee thresholds. Can you give us some insight into the current state of play? What is the current sort of position and thinking, and what are some of the issues, particularly with foreign transactions or global transactions, some of the issues that the Commission has faced either internally or from merging parties, and how has the Commission gone about resolving those or dealing with those? Over to you, Yemisi. You're on mute.
Thank you very much, Michael. Like my colleague, Mrs. Ojugo has already explained the introduction of the FCCPA into the introduction of the FCCPA, which repealed the ISA. The Commission has gone ahead to publish its instruments, which stemmed the Merger Review Framework, published its regulations, gun jumping guidance on gun jumping, notice on threshold, and the more detailed and explanatory Merger Review guidelines. Right now, recently, the Commission in August made a review and amended this regulation to include, so first off, reduce in a way renewed the matrix that generally reduces the applicable fees and clarifies the applicable turnover, which should be used for the purposes of calculating filing fee in respect to global transactions with a local effect, and also private investment entities. I would say here that the Commission is working on the way to publish its guidance note on the private investment entities and what it actually means in the point at which to know, okay, what fund what threshold will be used in terms of calculating its filing fee. Like you said, with respect to foreign transaction, then one of the major issues we've had is whose turnover are we going to use to calculate the filing fee? Are we using the global entity or the global turnover, or are we going to use the global consideration for this for the calculation of the fee? The Commission has gone ahead, like I said, in its amended regulation to narrow it down, to explain to stakeholders that the threshold that will be used is a threshold of the local component. So only the turnover of the local effects here will be used in calculating the threshold, in calculating the filing fee, sorry. So far, like I said, the threshold, which was published last year in September, has made the minimum, the threshold is met at where the combined turnover, it's at a minimum of 1 billion, and where the turnover of the target is at a minimum of 500 million. So once this threshold is determined, the parties can then go ahead to either consult the Commission as to which form they will use in filing. So either they use the Form 1, Form 2, or Form 4. So the Form 1 is the full merger review process. The Form 2 is the simplified process, and it applies where the Commission has requested a small merger to notify, or where none of the undertakings are active in the same product or geographical market, or where two undertakings are active in the same product or geographical market, but their combined turnover, their combined market share, sorry, is less than 15%. There's also the expedited process, which reduces the time frame for review, for merger review to 15 business days, more less. This expedited review can be, you will need to consult the Commission as to, oh, can I use the expedited review? Can I use the Form 1? And then finally, there's the Form 4, which is for negative clearance procedure. And then this negative clearance procedure is used when parties are unsure if the merger falls within the, if the merger should be notified. So for example, this applies to credit institutions or acquisitions of, say, less than 25% share of another company, and then mergers which are typically not notifiable. Yeah, basically.
Okay, I mean, certainly a clear move, clear demonstration that the Commission seems to be moving in a direction of wanting to ensure it remains very much aligned with international best practice, that it doesn't adopt a mechanic that gives rise to disproportionate filing fees that would, prejudice parties that just wouldn't make sense. You seems to be very much the approach that the Commission welcomes filings and has made tremendous efforts to try and reduce the burden on parties, both from a filing fee as well as a timing and the administrative requirements. And I think, certainly from our experience and having dealt with the Commission and the mergers we've filed, I think that's certainly borne out, and I think it's certainly something that's going to be very much welcomed by the international, well, not only the international community, the local community as well, and I think all business. Yemisi, the Commission launched its online merger portal, 4 to 6 weeks ago, I think.
Yes, in October. Yeah.
Quite a sophisticated quite a sophisticated move, I think, from a and technological space, quite advanced, not only in Africa but globally, I think. Talk us very briefly through what the portal was designed to achieve, why it was motivated, and how it's been functioning in the short time it's been up and running.
Okay. With the unfortunate COVID-19 pandemic, the Commission saw the need and importance of having a contactless and remote notification process that will be convenient and easy for both parties, that's the Commission and merging parties, and created the merger notification portal, which will be for notifying mergers and also for pre-consultation notifications. The portal right now is in force, and we're seeing the transition period. So for now, you can still bring physical copies to the Commission and still file using the portal. I think we've gotten good feedback from stakeholders concerning the portal. We've received a few notifications via the portal. Yeah, it also gives stakeholders the opportunity to pick any of the forms as it is in the regulation. So the portal does want to replicate what the regulation says, the Form 1, Form 2, and Form 4. The portal also shows, there's a part of the portal that also publishes the Form 1A of every merger notifications that come into the Commission, where we can get feedbacks from third parties interested in the merger, interested in giving information about the different mergers. Basically, it's been a smooth one for now. Yeah, for now it's been good, and yes.
Yeah, no, I think it's a tremendous initiative. I was going to ask a question, and I see a question has come up from the audience as well about the extent to which the Commission has prohibited a merger or imposed conditions on a merger to date. And there was a related question as to whether or not the Commission intends publishing its merger decisions, and if not, is there a reason why its decisions aren't published?
Thank you. Up to date, the Commission hasn't prohibited any merger yet. Was given quite a couple conditional approvals. And also the Commission is working to begin publishing its decisions, which I know next year or by the end of this year, some of the decisions that have been made will be published on the Commission's website.
So did I understand that correctly, that you have published, so you have issued conditions to the on merger?
Yes, conditions.
Yes. And what do those conditions relate to? Are they competition-related conditions or public interest related?
Yes, competition. No, most of them are competition-related. So structural remedies and those kind of things. Yeah, mostly structural remedies.
Okay, those are quite robust conditions to be imposed. And I'm sure, and I hope we'll read more about those in the decisions that are published. Turning then quickly to public interest considerations. Obviously, your legislation is very much mirrored on South Africa's in that regard. We know, and I think we're all quite familiar with the extent to which public interest considerations play a role in South African merger control. Nigeria may not quite have the same socioeconomic context as South Africa, and I think a lot of the clients would want to know is the level and extent to which public interest is taken into account. Not only, I think everyone appreciates that it can be taken into account from a legislative perspective, but practically, how is it being taken into account? How is it being assessed is it a weighted on an equal basis as competition considerations, or is it really I wouldn't say an afterthought, but is the focus really on competition issues? And unless there is a public interest element that stands out graphically, it doesn't play a material role in the decision.
Yes, the Commission takes public interest considerations to be very important, and they feature in merger analysis, and the competition. The FCCPA also provides for a few considerations when the commission is analyzing its mergers. For example, the impact of the merger in a particular sector or region. We looked at the employment issues that can come off post-merger, the abilities for small and medium enterprises to become competitive in that market, the ability for national industries to also compete globally. But before any of this can be relied on, it must be substantial and merger specific. And most for the commission, public interest comes up where a merger is likely to lead to a substantial prevention or lessening of competition. This is when the commission will consider whether there are public interest grounds to justify the merger. The commission also takes special regards to representation made by the minister, but this also has to be substantial and merger specific. The commission takes public interest considerations as very, very important while doing its merger analysis.
And the minister has, I presume, the powers of intervention,
Yes.
and intervene in the process. And how is that done? Is it done through a formal, that he has to formally intervene as a third party, or does he relay, or does the department relay their concerns to the commission?
Okay, so the minister at any point in time during a merger review can make his own representations concerning public interest grounds while the commission is in the process of review. And like I said earlier, these representations will still be considered by the commission, and it has to be able to, it must be, like I said earlier, substantial and merger specific. So at any point in analysis, the minister can write formally to the commission concerning making his representation about a merger to the commission.
We have a couple of minutes left. Let me just flick through these questions. We have one more question, which I think was partially addressed earlier by Eme, which relates to the extent to which parties who want immunity must admit their liability. And Eme, I think you mentioned earlier that yes, parties can come forward, and if they do, they must give full disclosure about the evidence and their nature or their involvement in a matter. I think the question, and it has come up in other jurisdictions, particularly in South Africa, where an admission of guilt is an absolute requirement, or whether there's even been parties who've paid penalties for alleged cartel conduct, but don't necessarily, or their settlement agreement doesn't necessarily include an admission of guilt. And there's a variety of reasons for that. I think parties are often prepared to pay a penalty to do away with the costs associated with litigation. And also there are other consequences like civil follow-on damages for a party who admits liability. So I think the question stems from those considerations, and therefore whether or not it's something which the commission has thought about. I know your leniency rules have not yet been published, but if not, is that something you've at least considered or debated as to whether or not it's an absolute requirement to admit liability, or is that something which you haven't yet grappled with?
So thank you very much, Mike. So far, we've had just I want to believe that it's an absolute requirement, but we have undertakings who have wanted to negotiate the extent to which they can admit their liability. So I want to believe that every case will be treated. No, I'm not going to toe that line, because so far we have insisted that they take absolute responsibility for their actions. Like I said, you do not plead half guilty. Oh, I'm half guilty, and I'm either guilty or I'm not guilty. So if we have to take that into consideration, if we want to benefit, if an undertaking wants to benefit from the Commission's leniency and cooperation rules, then admission has to be absolute.
Okay. Final two questions from my side, and then I think I see there's another question. The first is, we know that parties who are uncertain about whether their conduct may or may not contravene the Act may engage the Commission reactively before they implement the agreement and possibly get an authorization from the Commission. Is there a mechanism for parties who have already entered into agreements before the legislation and before these regulations came into play? Is there a mechanism for them to approach the Commission and obtain some level of comfort or disclosure? Is there a formal or informal mechanism, or do parties? Okay.
Definitely, they can do that, but it has to be formal. We know that we cannot apply the Act backwards for conduct that was carried out or agreements that were executed and enforced prior to the Act, but the Act is in place. You know, we all, as lawyers, we always say ignorance of the law is no excuse. So we would expect that undertakings who have actually engaged in restrictive practices or entered into a restrictive agreement with another undertaking would approach the Commission and see how it could be worked out, and definitely just put the Commission through the efficiencies on why it was necessary and all of that. But and you know, like we said, those restrictions, the effect, the anti-competitive effect has to be indispensable. That particular act has to be is indispensable to what you want to achieve. So if in the Commission's review, we've seen that this efficiency can actually be achieved in some other way, I'm sure parties would have to modify behavior and generally just align themselves with the provisions of the Act. So yes, definitely, the Commission keeps an open door policy. We are willing to listen. We do not just want the market to just go in limbo and just there's confusion everywhere. So definitely, if any restrictive agreement has been carried out before the passage of the law, parties are welcome to approach the Commission, and we will walk ourselves through each and every circumstance that comes up. So that's it.
Makes a lot of sense. And then the final question is the extent of collaboration, if any, that the Commission has with other regulatory agencies, both international and across the African continent. Are there agencies that you're particularly close with, memorandums of understanding being entered into, information sharing, anything like that?
Yeah. So I'm going to start nationally. The law requires the Commission to negotiate agreements with all government agencies whose mandate includes enforcement of competition and consumer protection for the purpose of harmonizing the exercise of jurisdiction and ensuring a consistent application of the provisions of the Act. So yes, on the national plane, the Commission is really towing this line. We've had agreements with SEC. We are in negotiations with many others. Incidentally, it's one of my core responsibilities. You know, we're reaching out to these agencies and telling them, look, we need to work together. And for some of them, we've gone an extensive way in terms of drafting our MOUs. We have first and second drafts for some of these MOUs, and we're just looking forward to execution and implementation. So yes, nationally, we are working with a whole lot of our sector regulators and sister agencies just to ensure that we promote economic efficiency across all sectors of the market. On the international plane, we've had trainings with the Federal Trade Commission. Federal Trade Commission is the United States Consumer Protection and Competition Agency. They trained us in person and virtually, and they even trained just before we embarked on our dawn raids and execution of search warrants. So yes, definitely we've had that. We've had staff who have been trained in Egyptian competition authority. They've had courses over there. And we currently have an MOU we are negotiating with the South African Competition Authority. We also have a tripartite MOU with the Economic and Financial Crimes Commission here in Nigeria and the FTC to strengthen cooperation and collaboration in addressing mutual cross-border consumer protection and fraud concerns and problems. So yes, definitely, we have representation on ECA, in COMESA, in ICN. So we're definitely, because we are teaching, it's important that we work with people who have gone ahead of us. We do not need to go through those experiences to learn. We can glean from their experience and make it even better, make it even work better, knowing that these agencies, these authorities have already worked this way. So yes, definitely the Commission is interacting with agencies on the global level, on the regional level, and in the national level. So yeah, we're doing that.
Yemisi, thank you so much for your time speaking to us. I think we covered a tremendous amount of ground and topics, and on this call, I think it's been very insightful, certainly for me, and I'm hoping for our audience as well. So thank you so much for your time again. And if there's any audience members who have any follow-up questions for us, please send those through. We'll try and address them after the session. But thank you for joining us, and have a lovely day further. Thank you very much.
Thank you so much, Mike. You too have a lovely day.
Thank you very much. Yeah.
Bye.